and welcome to Commercial Collections Corner, episode 5, When Creditors Merge, Who Can Enforce the Debt? My name is Chauncey Hitchcock, and I'm an attorney at Weltman, Weinberg & Reese in our Detroit office in Troy, Michigan. In my role at Weltman, I'm responsible for pursuing collections on commercial accounts throughout the state of Michigan. I joined Weltman this past year in September after working for Michigan-based law firms on business and real estate litigation, including creditors' rights for corporate clients, and spending nearly 2 decades as in-house counsel at regional and national companies in the commercial real estate, healthcare, early childhood education, and automotive industries. I'm a graduate of the University of Michigan in Ann Arbor, go Blue, and attended DePaul University College of Law in Chicago, Illinois, while working at the Kirkland & Ellis law firm before graduating from Michigan State University College of Law in East Lansing, Michigan. Go Green. I find my work at Weltman both interesting and challenging, as it allows me to use my litigation and negotiation experience, as well as my familiarity with how companies operate from my experience on the inside, to devise strategies to achieve our clients' objectives. As a reminder, this is an interactive session, so please submit your questions through the question button in the control panel. Questions will be addressed during the presentation where applicable. This webinar is being recorded. At the conclusion of today's session, a link to the recording and a copy of the presentation slides will be sent to all attendees. Thank you again for attending. Also, there will be a short survey on your screen at the conclusion of this event. If you kindly please take the survey and share your feedback, we would greatly appreciate hearing your opinions on our webinars. I'd like to make a special thank you to Ariel Bowles, our marketing coordinator, and Owen O'Connor, our marketing analyst, who have helped me greatly in assisting with this webinar. But without further ado, let's begin. Okay, first, I'd like you to take a quick poll, if you could, about how you heard about our webinars and vote in the poll. Select one of them if you heard about them at a conference, from a Weltman employee, or via social media. Useful to us to know. Okay, switch to the next. Okay. All right, let's get started. Well, this is a take on a common phrase you probably heard, but my modification. There are 3 things that are certain in life: death, taxes, which I think some of us are probably still finishing, and mergers. Regarding mergers, in this webinar, we will address what standing a successor creditor has to enforce the contract that the predecessor creditor entered in with the debtor. Good switch. Many of you know this, an action must be brought by a real party in interest. Michigan court rules, specifically in Michigan MCR 2.201B, requires that an action must be prosecuted in the manner of the real property in interest, and is subject to certain provisions. This requirement, of course, is not unique to Michigan. What is a real party of interest, and how does a creditor, and particularly a successor creditor, show that it is one in order to be able to enforce the debt? Good switch. Okay, the basics. What is a merger? When 2 companies merge, they combine to form a single new entity. pooling their assets, liabilities, operations to increase efficiency, market share, and reduce competition. A bank merger, for example, is a combination of two or more financial institutions into a single entity. Next slide, please. Okay. On mergers, what is the effect and the ability of a new entity after a merger to enforce the debt held by the predecessor creditor prior to the merger? So following a merger of financial institutions, the new entity is said to have stepped into the shoes of the creditor entity that merged into that entity. And before I get to a discussion of a recent Michigan Court of Appeals decision on that, when I was deciding to present on this topic, I was thinking a lot about stepping into the shoes of something. And it reminded me of a movie that many of you probably saw as children, maybe in recent years, Wizard of Oz. And when Dorothy effectively steps into the shoes of the Wicked Witch of the East, whose house following the tornado lands on, and the shoes attach themselves firmly to Dorothy's feet, and the rest is cinematic history. So in any event, it caught my attention, particularly when I saw this opinion released near the end of last year. So a recent Court of Appeals decision in an unpublished opinion, the court found that the trial court did not err in finding that the right of the creditor entity, the bank in this case, to enforce a contract, the loan debt, occurred by operation of law following the merger. The court found that the new entity stepped into the shoes of the prior creditor without any further action by it. Next slide. The case on point. Huntington National Bank versus Riemann et al. That's Michigan Court of Appeals unpublished opinion from December of 2025. So in this case that I ran across a few months ago, it addressed whether Huntington Bank was entitled to sue the debtor. Riemann happened to be an attorney himself for breach of contract for non-payment of a promissory note. Here are the facts. In 2013, Riemann and his law partner executed a promissory note, standard promissory note, in favor of what was then Chemical Bank for just over $300,000 that was secured by a mortgage on their law office building. Next slide. Okay. The promissory note matured in 2018 without payment, which resulted in debtor's default on the loan with Chemical Bank. Chemical Bank in 2019 notified debtors of the default on the loan and demanded payment in full. Okay. Now we get to the mergers that are involved in this case. Merger one, also in 2019, Chemical Bank, which was a local bank here in Michigan, based in Midland, that was associated with Dow Chemical Company. Basically, that's how it got its origins, but it merged with TCF Bank, which I'm sure many of you have heard of. And then we have yet another merger. In 2021, TCF merged with Huntington National Bank. Next slide, please. Okay. The suit. Huntington sued Riemann and his law partner for breach of contract. Huntington's claim versus Riemann went to trial Interestingly, it was noted that it was a 3-day bench trial, which I'm sure was quite a bit of fun. Huntington's only witness was its asset recovery officer who was responsible for the loan. And she testified as to the 2 mergers I previously mentioned, as well as her belief that Huntington became the owner of the loan and that Huntington continued to service the loan, is what she testified to. The trial court, lower court, Bay County, indicated, determined by a preponderance of the evidence that Riemann, the defendant debtor, was liable for breach of contract. There was a default judgment entered as to his law partner who did not respond to the proceedings. Next slide, please. Okay. Let's see. Okay, we have a break here for some questions, and wanted to know if anyone on the webinar today has run into a similar situation in a case in which the debtor argued that your client did not have an interest in the contract / debt when the debtor entered the contract with another entity prior to the merger. And if so, how did you address that? And how did the court respond? If anyone would like to ask a question, feel free to do so. And also another question, and welcome all comments too. What best practices do you employ when heading into court to stave off a potential challenge by the debtor to your client's right to enforce the debt? Feel free to send that in the chat now or at any time during the presentation. Be happy to respond to that. All right, well, seeing none at this point, and I can address them as they come up, why don't we move on to the next slide? Okay, this is the Huntington versus Riemann case continued, which was appeal of trial court's finding that the debtor was liable on the promissory note. Okay, so on appeal, the debtor argued that Huntington did not provide sufficient evidence that Huntington was entitled to sue the debtor for breach of contract. That is, that it was not the party of interest owning the loan. The court noted that the debtor did not provide any law requiring in his appeal that plaintiff in a breach of contract claim involving a prom note through a merger to produce the merger agreement. The court, though, found that a merger agreement in this instance would have been cumulative anyway, in light of the asset recovery officer's testimony that Huntington acquired the loan through mergers. Can't stress the importance of having a good witness to testify that, and Huntington did in this instance. Next slide, please. Okay, case continued. Court of Appeals on the effect of the merger, one entity stepping into the shoes of the other with no need for a formal transfer of assets. The court addressed the effect of a merger with respect to transfer of ownership finding. In a merger under traditional banking and corporate law, one entity merely steps into the shoes of the other, and there is no need to transfer assets. The transaction occurs without any voluntary or affirmative action in a merger and is a transfer by operation of law, citing Kim versus JP Morgan Chase Bank, NA, which is a case that's not totally on point. The Michigan Supreme Court case from 2012 that involved a transfer by purchase agreement from FDIC to another bank. But the Michigan Court of Appeals in Huntington versus Freeman latched into that concept of stepping into the shoes of the other party. So the court's holding here. The court upheld the trial court's finding that the debtor was liable to Huntington Bank for breach of contract due to its default in the prom note / loan, stating that it was not persuaded by the debtor's argument that Huntington had no authority to collect on the debt because the promissory note then is not a chemical bank note, but rather with the merger became a promissory note of Huntington National Bank. So it was very interesting argument, I think, that was raised. Faulty did not hold sway on the court by an attorney litigant. And I've run into, over the course of many years, the debtors, and much less frequently, attorneys questioning who's actually the owner of the note. But with the advent of so many mergers, and we see one bank merging with another, and so on, that this is a question that comes up, and in this instance came and was addressed by the Court of Appeals here in Michigan. Next slide, please. Takeaways. Okay. Well, this particular opinion of the Michigan Court of Appeals being unpublished is not precedent. It certainly is persuasive. May be used for such, and may be used to support an argument that a creditor, such as a bank or any entity, steps into the shoes of the other entity, prior bank, following a merger, and should not be necessary to show formal transfer of an asset, as transfer of assets occurred by operation of law through the merger, and the newer surviving entity now owns the debt and may bring an action to enforce the debt, having stepped into the shoes of the other original creditor and owns the debt. So it certainly can be used for that reason. And as the next slides will show, I believe this is an instance of something that's going to come up even further. Why does the court's ruling matter? Significance of this ruling is it challenges to a creditor or any party's interest in a contract. For example, debt instrument are likely to increase exponentially in the years to come. Mergers, and particularly bank mergers, are increasing due to a number of factors: consolidation, competition, other factors. And last year alone, there were over 170 bank mergers. In the 1980s, when I was growing up, I'm sure I dated myself by the Wizard of Oz reference, there were over 14,000 FDIC insured institutions. Today, there are fewer than 4,000. Expect continued consolidation and what you might call merger mania to continue. And I'm seeing much more of it myself. Next slide, please. Okay. Conclusion, how do you prepare and address for a challenge to ownership of a debt after a merger? I mean, there's no panacea, cure all for parties' interest in a contract being challenged, following a merger. whenever possible, produce a merger agreement, but more importantly, equally importantly, or perhaps more importantly, produce a witness who can testify as to the debt and the merger or mergers with some certainty, and use the rationale of the Michigan Court of Appeals in Huntington v. Riemann, in which even a crafty attorney litigant could not evade liability on a debt by arguing he was not, quote unquote, liable to Huntington Bank as he contracted with Chemical Bank over 2 mergers ago. So very important to have that witness who can testify. You're not always going to have the witness that Huntington had in this instance, who had been, back, actually went over, in this case, went over from Chemical to TCF to Huntington. But as the attorneys and others know, no case is perfect. You do the best you can, but to have someone who can testify as to the debt and mergers involved will certainly help your cause. Next slide, please. I want to thank everyone for attending today. We have quite a bit more time available, and I'm happy to take and answer questions regarding that. And if anyone would like a copy of the case that I've discussed today, I'd be happy to have it posted by our team here, or send it separately to you. Truly appreciate your time on this webinar today. It's a topic that's going to continue to come up, and I see it. I see it, not on necessarily a daily basis, but I see it quite frequently, where debtors, sophisticated, unsophisticated, they're raising the issue. I never contracted with that party, and I sort of understand their point, but it was, you hear it enough times, and when I saw this case come out in December on point by Michigan Court of Appeals, this is something that I think will be challenged with some increasing frequency, and better be prepared for it. I think ultimately going to prevail on the point, but you can expect, I think, these challenges with the advent of mergers and continued and increased mergers to continue and to increase. But thanks again for attending today. I truly appreciate you taking time out of your day to do this. Please consider Weltman, single source for every single creditor. Please feel free to contact me at any time. My contact information is there, as well as a cell phone, and I'm happy to share everything that I've experienced and come across, including this case. But I'd like to request again, if anyone has any questions that they'd like to ask, be pleased to take them and address them as best I can. Give you just a minute. I also have that other case that was cited, the Kim versus Chase Bank. So I'd be happy to provide that as well. That's interesting. Not totally on topic, but it's not always going to be a merger. Sometimes it's going to be by the purchase agreement. But there's some good discussion in there. But this particular case was on point and I think is interesting. And having gone before Court of Appeals in Michigan anyway, myself, it was welcome to see them use that rationale, because I've had some matters where I question the rationale and they seem to get it. But, well, it doesn't look like there are any questions now, but again, you have my contact information. Feel free to contact me at any time. And any other slides? I think there we are. I thought there was one more. Please do follow Weltman on social media. You can find us on LinkedIn, Facebook, TikTok, YouTube, and X, formerly known as Twitter. We're very active in those spaces, and would love to have you follow us. And I want to thank everyone for your time today.